Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Good morning. We are here on two different matters. First case on the docket is 2020 CR 185, State of Tennessee versus Stephen P. Lane. This is the defense's motion for a new trial. Bellmowers, are you ready? State ready?
Morning, Your Honor.
Good morning.
First, there's a preliminary issue. There's a typo on page 1 in the second paragraph of the motion. It references page 96 of the transcript. It should be page 196. When I went to look that up last night, I realized that 96 was 100 pages off where it should be. So that should be 196 as the reference in the transcript. Your Honor.
Hold on just a second. You were saying that in the paragraph number 2, where it says there was no deception or coercion in obtaining control of the funds, transcript 96, it should be what?
196, Your Honor.
Okay.
Your Honor, this case obviously was initially indicted as a contractor fraud case and a theft case. Mr. Lane was acquitted of the home improvement or contractor fraud case and found guilty of theft. The case that is instructed to this case, I realized as I was digging in, actually came from this court, State versus White. It's a 2024 case from the Court of Criminal Appeals, Lexus 235 and Westlaw 246875. And it discusses two cases, Ammons and Hutchison. And it contrasts those two cases through White. And it also mentions State versus Pardue, which is another case from this court. And the issue in this case is theft. And what is theft? Theft is either taking something that belongs to someone else without their consent. That's option 1. Or option 2, convincing someone to give you something through deception or coercion, which negates the consent that was otherwise given. The facts in this case are that Mr. Lane entered into a contract with Miss Worling to build a home. And it was not a cost plus contract, but a fixed price contract, which kept the risk of loss on Mr. Lane throughout the entire process. So Miss Worling paid an initial deposit that was to be part of the purchase price of the home. That's reflected in the contract, I believe Exhibit 6, that was going to be part of the home. That was part of the price paid to Mr. Lane. He wasn't to hold that in escrow or to keep it. It was to be paid as part of the price. And then the process was Mr. Lane would present an invoice to Miss Worling. And Miss Worling, per the contract, was to pay Mr. Lane. However, as is very very ordinary in construction contracts with construction loan, Miss Worling didn't have the money to pay Mr. Lane the contracts. So she would go to the bank and request the money, the draw from her loan, before she would pay Mr. Lane. So that involved the bank approving any money before it was released to Miss Worling to be able to pay Mr. Lane. And in this particular case, because it was a VA loan, it was a little more stringent as to the inspection process. So there was the initial deposit, and then there were a series of invoices that were presented to Miss Worling, and she wrote a check and paid Mr. Lane for those invoices. So a check is a negotiable instrument, is an unconditional promise to pay. So what that means, when I sign that check, I'm agreeing that I owe you the money and that I must pay you. And that's discussed in 47.3.104 negotiable instruments definitions, and it can get way off in the weeds. But when I write you a check and I hand you that check, I'm saying I owe you this money and I'm going to pay it, or my bank's going to pay it on my behalf. Once that gets to the bank, they're going to give you the cash. And that's exactly what happened. The checks were delivered. He delivered those checks to the bank. He was given cash. And then another issue is the holding by your honor. So in the transcript, page 196 to 197, we discussed the jury charge and whether the language discussing coercion or deception would be included in the jury charge. And your honor ruled it would not because it had not been raised in the trial. And the state agreed that it would not be included in the jury charge. So that only leaves us with option 1 of theft. Option 2 of theft has already been ruled by designing that jury charge that flavor of theft was
I
not.
don't see anything about your objection to the jury charge in your motion for new trial.
Well, it's not because the court ruled they agreed with us. We asked that it not be included. You said it wouldn't be included because it wasn't fairly raised. So there wasn't an issue with the jury charge that was used. It matched what the court had ruled. But at that time, when the court made that ruling, the second option of coercion or deception had already been ruled, did not apply in this case. So it was not here. So the only option left for the jury to consider was theft, is taking something without someone's consent. Clearly, Mr. Lane didn't have Ms. Worley's checkbook. He didn't write the check. He didn't take money out of a safe. He didn't take materials off the job site. There's no allegations of that. The allegations were, in essence, buyer's remorse. She wasn't happy with what she paid him. The bank said, we're not going to continue to give you draws. Mr. Lane presented an invoice. They never paid it. There was a civil case filed that Mr. Lane was victorious in that somehow has now been reopened. I don't know the details of that. And we did ask that be brought into evidence, and the court overruled that. And that goes to what I believe is a mistake of fact, which we would have had the right to argue or to ask for a jury charge, but that piece of evidence did not come in, is that Mr. Lane believed he had a final judgment against Ms. Lane for a certain amount of money. And so even if there was some requirement that Mr. Lane refund the deposit or a piece of the deposit or a part of the deposit, the fact that he believed he had a valid judgment against Ms. Worling would eliminate the intent portion of theft, that he intended to deprive her of her property. If he believed it was his property, even if he was mistaken, you couldn't intend to take something from someone else if you believed it was yours. And Your Honor, the case on that about deposits goes back to exactly State versus Ammons, which in that case, a gentleman got a deposit or got a payment from a lady, put the money on deposit with 84 Lumber in Knoxville, got ran off from building the house due to arguments over workmanship, and eventually went to 84 Lumber and retrieved the deposit and pocketed it. And the Court of Criminal Appeals said that's not a crime. It's bad business. It's a violation of contract. It's a breach of contract, but it's not a crime. And here in this case, Your Honor made the point several times. Mr. Belmarsh, you're trying to argue a civil case. This isn't a civil case. This is a criminal case. Well, Your Honor, it is a civil case. It should have been a civil case. Should never have been a criminal case. And State versus White spends a lot of time discussing that over and over, that deception occurs only when promise of performance at the time that the person knew the person did not have the ability to perform, or that the person does not intend to perform, or knows that he will not perform, except mere failure to perform is insufficient to establish. So what had to have been proven is that at the time they contracted, at the time the deposit was given, that Mr. Lane had no intention to ever complete this project. And there's nothing on the record to do that. He was there for months. He kept coming back. He kept trying to remedy the situation. It just simply, the proof does not line up with what's required under Ammons and White. As to the remaining things in the motion for new trial, again, the case mirrors Ammons in the fact that Ms. Worling ran Mr. Lane off. He was there that day. He left to go to the sheriff's office to report that she wouldn't let him obtain his property. They were still trying to work things out even up to that day. And then, Your Honor, lastly, in paragraph 6, we had asked that the YouTube be turned off or be put in a place where the jury could not review it overnight or while the case was pending, and the court denied that motion. I don't believe there's anything out there to support that. That's, I guess, would be an issue of invades the province or gives them an opportunity to review it. But we certainly didn't have anything in the record to show us that they reviewed that footage or anything after the trial.
General Wojnarowski?
Good morning. Your Honor, obviously this case was heard over 3 years ago, so some of the facts may not be as fresh on my mind or your mind or any others at this point in time. However, looking back through the transcripts, there's various points, obviously, that the defense is making in regards to motion for a new trial. The first one being that the jury's verdict is not supported by the evidence. Obviously, Your Honor, you heard the evidence as well as the jury did. The jury came back guilty, and you affirmed as the 13th juror. And this was after 3 days of testimony, of exhibits that were presented. The jurors spent time deliberating. They then deliberated in the evening. They went back home, spent the night, came back in the morning. They deliberated again. They asked multitudes of questions throughout the trial. They were very engaged, and ultimately they deliberated and found Mr. Lane guilty of theft, but not guilty of the home improvement fraud, which I would argue is evidence of careful deliberation and consideration of all the evidence at trial. And I would argue the evidence was sufficient. Evidence was sufficient for the case. The second and third sort of go together in the amended motion for new trial. But in regards to, there's some argument about jury instructions, and at least in my file, I show that there's a final charge of jury instructions that at least gives instructions in regards to effective consent, which does discuss deception and coercion. So I show that was in the jury charge. However, I could be incorrect. I don't have a signed version of it. I have one that's a copy in my file. Your Honor, you gave the jury instructions and definitions that the jurors used in making a determination in this case. Those instructions were based on law that is required to be provided. And there were multiple proofs shown at trial in regards to the intent of Mr. Lane and types of deception or fraud, basically, that did occur. And I would point out a couple of different ones just for the court's remembrance that was evidence put on by the state. Obviously, there was some argument between defense and state evidence. However, the state put on evidence that Mr. Lane did not pull a permit until almost a year after starting the build, and that was provided for in the files by the office in regards to permits. That he made repeated promises over 4 separate times to pour concrete that had been paid for by Ms. Whirling, and each time he said he was coming to do it and then never did show up and never did do it. Mr. Lane submitted bills and invoices for items that had not been completed or had already been paid for. So I'd argue that money had been provided for specific purposes by Ms. Whirling to the defendant, and he did not provide those services or those items. There was evidence shown that Mr. Lane came to the property and took the forms off of her property, these ICF forms that were like the walls. And she had paid for those items and ultimately needed new ones or more of that in order to build the second floor, which she did later on with the new builder. In regards to, there's parts in number 3 in which there's arguments over whether or not the victim demanded the defendant leave the property and never return. The testimony from Ms. Worling is that she repeatedly asked the defendant to complete the project. There were emails, there was communications, there were text messages in which she wanted him to do the work. She wanted him to pour the concrete. She wanted to move this build along. This build had been sitting there for approximately, I'm trying to remember the exact date, but it started in August of 2018. And by the time this all came about, it's 2020 when these charges came about. She wanted her house finished. Mr. Lane just continued to give empty promises, and that at the time that he came over to her house to get more money without actually doing any work is the time in which she told him to leave. Number 4 shows that the court excluded evidence of a civil lawsuit. Judge, if you'll look back through the transcript, there is a lot of leeway that had been given, and the court did allow testimony that the defendant had sued Ms. Worling civilly to obtain his scaffolding and other items that he said were his that were left at the property. And then it was allowed in that the court ruled for him after Ms. Worling didn't come to court. All of that evidence came out. The only thing that the court did exclude at some point in time was that the court found that in order to again, I'm not even sure exactly what the lawsuit was that he's talking about. At the time of trial, I believe the only lawsuit that was there was in regards to I think it's called replevin, but the replevin of his property that was at her home. That was the only lawsuit that I was aware of, and that's the evidence that came about. He ultimately tried to ask more details in regards to a lawsuit, and the court found that that was irrelevant and that there's no reason to allow such information in a criminal case due to being information about like an offset or something along those lines. I think that was the appropriate ruling in this case, because obviously the jury was still able to hear information in regards to the dispute and what happened involving the equipment that was left or property that was left at her home. And then in regards to count number 5, Judge, where they asked that if the verdict was allowed to stand, to reduce the judgment to $13,244.73. I would point out the fact that the jury listened to all the evidence and they received all the documents, and the state in this case had asked for restitution in the amount of $24,000. But the jury came up with what they felt was appropriate based on listening to all the evidence, looking at all of the exhibits, and they came up with the number $21,944.73. I would argue that that number should in fact stand, because obviously it involves a careful deliberation and of a figure that they felt was appropriate in this case. In number 6, Judge, this issue was addressed as well. Obviously, the court does have a YouTube video, and that was addressed to the jurors both at the beginning as well as before they left, to not research this case, to go home, get some sleep, don't do any research, don't look at anything, don't do any legal research, don't do anything that has to do with the case whatsoever. And you gave the jurors instructions. The next morning, when they came in, Your Honor polled the jury and asked if any of them had looked at the YouTube video or comments that prior evening, and all of them said they didn't. So I would argue that there is no error or harm in that situation, because none of the jurors agreed that they had reviewed any of that footage. So I would ask the court to deny the motion for new trial.
Mr. Bellmeyer, do you have anything else?
When Mr. Lane obtained the forms that the state is saying that he had a court order telling him he could go get them. So I don't know how that could be theft. He had a court order telling him he could go get the forms, the ICF forms. But here we're back to the same point, and the issue in the case is it's a civil issue. Promises to pour concrete that were paid for, that's a civil issue. That there were things in the invoice that were paid for and not provided. Repeated promises to pour concrete, and the permit was gotten a year later. There was tons of evidence about the permits. But, Your Honor, the issue still remains that Miss Whirling wasn't at some far-off place. She wasn't not at the site. And that testimony came out. It was very clear from her. She participated. She knew exactly what work had been done and exactly what work had not been done. She was given invoices. There was a provision in the contract that gave her time to review that and object. She didn't object. Not only did she not object, she handed him a check. The only invoice she objected to was at the end, and Mr. Lane was there trying to get an invoice paid that he had modified. He had taken off the concrete that had not been paid, that had not been poured. He had removed that and tried to get paid for what had been done. And that's the only invoice that was ever in controversy, and that's the invoice that was never paid. And that's what led to a civil suit, getting his property back. That's what led to the money judgment. And then now, I don't know, again, it's been appealed, and it's back open in circuit court. But anyway, Your Honor, it's not theft. It doesn't meet the statute. A crime can't be created in a case because the state wants there to be a crime there. It has to be exactly what the law is. And here, the theft has to be when he exercised control of the property, unless he was holding it in trust. He never was holding anything in trust.
This case is a perfect example of the problems that arise when a continuance is repeatedly granted to either side and delay the entry of a final judgment in the case. These crimes were allegedly crimes. Those indictment charges that these events occurred that led to the indictment in August of 2018 and July of 2019. The trial, he was indicted by a grand jury in 2020. The trial was conducted in 2022. The sentencing hearing was held in 2022, and the court put down its ruling. The defendant filed a motion for new trial December the 5th, 2022. That is the motion for new trial that's now been amended by an amended motion for new trial filed September the 29th of 2025. So this case, after the conviction of the defendant, who was sentenced to 3 years and placed on probation, that case, basically his sentence expired on November the 7th of 2025, except for the fact I think there's a violation of probation warrant that's been issued. I wonder if we would be even hearing this motion for new trial if there wasn't a pending warrant for violation of probation. In any event, the amended motion for new trial basically raises some issues that were not raised in the original motion for new trial. And it's regrettable that it's taken 3 years to get to this point. The court will have to take the matter under advisement because of the fact that there are allegations made regarding events that occurred in the transcript and provisions of the 3-volume transcript that were cited in this motion. This court, after 3 years, will have to go back and reread the transcript to determine how it's determined. I can tell you that I will tell you right now that I do not believe and will hold that the fact that I allowed the YouTube of the trial to remain out there is not an error, because we always charge jurors and give them instructions regarding research. As General Wojnarowski pointed out, we tell them not to do any research, not to do anything else. We have cases where it's not the YouTube, but there's television coverage of events that occur. We tell those jurors the same thing we told these jurors. And the fact that I brought them in the next morning and inquired, Mr. Bell Myers would have to be alleging that the jurors lied to the court when they said they complied with the court's orders and did not view anything or do any kind of investigation. I'm not prepared to say that that is the case. There is law that says essentially, case law that says essentially, when you instruct a jury to follow your instructions, you presume that they will, and absent some showing that they did not, it is just the mere allegation that that video remained up for public viewing. This is a public court, and that's the reason that this court continues to live stream its proceedings, because it is a public proceeding. So I will tell you that number 6 on your motion, amended motion for new trial, is respectfully denied. The remaining allegations are going to be taken under advisement by the court. Sometime, I guess, based on how this has been conducted up to this point, sometime in the next 3 years, I'll give you a ruling regarding the motion for new trial. So obviously, I'm required by law to conduct or to give you a ruling sooner than 3 years. My statement about that is only to illustrate frustration this court feels with having a case 3 years after the trial now come up for a motion for new trial. The defendant is the one who repeatedly sought motions to continue the sentencing hearing or the motion for new trial so that a transcript could be obtained. So unfortunately, he will remain on probation and pending, I guess the probation remains open until I can make a ruling one way or the other, because this probation violation, I assume, won't be heard until after I've given you a ruling on the motion for new trial. So sometime in the next little bit, I will try to get you a ruling on your motion for new trial. I've taken it under advisement.